The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow it. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime, and it is not evidence of anything. The defendant is charged in count 1 with driving on a revoked license. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant was driving a motor vehicle during a time when the defendant's privilege to do so was revoked. The defendant is charged in count 2 with retaliation for past action. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant harmed or threatened to harm the alleged victim, who was a law enforcement officer, in retaliation for anything the law enforcement officer did in an official capacity as a law enforcement officer. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea about what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After that state's opening statement, this says an attorney for the defendant. It's a standard charge, but the defendant himself may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law you are to use in reaching your verdict. After you hear my instructions, I will select and excuse the alternate juror, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Excuse me. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, and then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question, or the reason that it could not be asked, please ask after court is adjourned, and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You're not required to accept or reject everything a witness says.
The courtroom is completely calm. The judge's tone is controlled and steady. But standing on the other side is a defendant who is visibly boiling inside. This case is not just about the law. It's a live example of ego, anger, and the sovereign citizen mindset, where a simple traffic stop slowly turns into a serious criminal case.
You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up in your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you've heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you are instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any opinion, any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial, therefore you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You're not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. First, do not discuss this case among yourselves during the trial until I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspaper, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. You may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook, Messenger, Skype, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on video or shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decision solely on the evidence you hear in the courtroom. I will remind you of your duty and responsibilities before all breaks in jury out hearings and trust you will follow my instructions in keeping with the integrity of the case in court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in the case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I'll try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1. If you need for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to the case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you, and the next phase of the trial is the formal reading to you of the indictments in this case. General Bryson, you may read the indictment.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, November term, Grand Jury 2022. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about June 18th, 2022, in Dickson County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn then and there did unlawfully and willfully drive a motor vehicle upon a public highway in Dickson County, Tennessee, at the time when the privilege of the defendant to do so was canceled, suspended, or revoked, in violation of Tennessee Code Annotated 5550-504, all of which is against the peace and dignity of the state of Tennessee. And the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about June 18th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sharik Marquis Vaughn then and there did unlawfully and knowingly harm or threaten to harm Officer Lindsay Javins by any unlawful act in retaliation for anything Officer Lindsay Javins did in an official capacity in violation of Tennessee Code Annotated 39, 16, 510, all of which is against the peace and dignity of the state of Tennessee. Signed by W. Ray Crouch Jr., District Attorney General.
Mr. Vaughn, as to that indictment and to those two counts, how does you plead?
Your Honor, I would like to change my plea. I would like to plead guilty to count 1 and not guilty to count 2.
All right. Ladies and gentlemen, the defendant has pled guilty to count 1, so that count you will not have to consider in your determinations in this matter. He has pled not guilty to count 2, and we will allow that to be entered as a not guilty plea. We are now ready to proceed to the next step, which would be the opening statements, and we're at the noon hour. I would suggest that we begin after lunch with opening statements, and then we move to the testimony. Ladies and gentlemen, I've given you a set of instructions that are how to monitor your progress in this case and how to monitor your behavior. I would just remind you that it's very important that you not discuss this case among yourselves. You're free to go anywhere you want to go for lunch. You're not under any sort of restrictions, but when you come back, gather you want them down in the jury assembly room. If you'll go back where you went to first thing this morning, they will bring you up through the back elevator and have you in the jury room so that you can kind of keep you isolated from everybody else. So we are now going to stand in recess. We'll give you until, let's try to be back at 1:15, and if at all possible. If it's a little later than that, we won't start without you, but we'll see if we can all be back by 1:15 and get started. We'll stand in recess to 1:15. All right, anything before we bring the jury in?
Judge, I wanted to address one thing briefly before the jury came in. When I read the indictment, I of course read it as would be anticipated for a bifurcated trial. So the defendant is charged with driving on revoked third offense, and I just wanted to be clear for the record that that was what he was pleading to.
It is clear for the record that the defendant is in fact charged with third offense, but because it is a bifurcated trial, I'm sure Mr. Spratt has probably explained that to you, Mr. Vaughn, but a bifurcated trial means under our rules, the jury cannot hear that you have been twice before convicted of driving on a revoked license. They only know that's your charge. So we will have the trial, and because on the third or the second count, but because you have been convicted of a driving on a revoked license, you have pled guilty to that, then it was a third offense. Is there going to be any contest about that being a third offense? Because under the rules, what would happen is that we would have to have a bifurcated section that for the jury to determine whether or not you had 2 prior convictions.
I believe the state's got 2 witnesses. I'm not holding them.
Turn your microphone on.
It's on.
I'm sorry. I think the state's got 2 witnesses, and I'm not going to hold General Bryson to that, or Mr. Vaughn's not either, but before Corporal Stewart's testimony, we may have a short jury out on an issue with his testimony. But that, I think, should be the only thing that's taken up.
All right. Then you have some issue, there's nothing been filed to my knowledge that would affect that, but we'll take that up whenever it gets to it.
And, well, I can address the reason it hasn't been filed to now or later.
Do what?
The reason that it hasn't been filed,
Go ahead.
because I think it just probably came to light at the motion hearing. Necessariness for it. Necessary, as to the necessity of it. I'm sorry.
All right, well, the jury's been sworn, we're proceeding with the trial. He's pled guilty to count 1. We will move to count 2, which is count 2, because we've obliterated the original count 2, and now count 3 is count 2. So let's go ahead and put on our proof regarding that, and when you get to a witness that you need a jury out hearing, you will need to allow me to let me know, and then Mr. Vaughn can argue as whatever it is he wants to argue. All right, bring out the jury, please. All right, thank you, ladies and gentlemen. We are now ready to proceed with the opening statements of the parties if they choose to make one.
What's really happening here is that the defendant believes he is a sovereign citizen, meaning he refuses to recognize the authority of the court or the laws of the state. The case begins with a straightforward charge: driving on a revoked license. That part is simple, technical, and the defendant even admits guilt. However, the real drama starts with count 2, retaliation for a past action. The state argues that when a police officer arrested the defendant and took him to jail while performing her official duties, the defendant responded with threats fueled by rage. Under the law, threatening a law enforcement officer because of their official actions is not just angry speech. It can rise to the level of a serious felony.
You are going to get a snapshot of the incidents that happened on June the 22nd of 2022. The defendant having already pled to driving on revoked, the state will be presenting proof, in our case in chief, only on the charge of retaliation for past action. Now, what you will hear in the proof is that on that night, Officer Javins had a reason to stop and talk to Mr. Vaughn, and that Mr. Vaughn, the defendant, was arrested. You will be able to see the video of when he arrives at the jail and begins to make comments to Officer Javins. Okay. You will be able to hear his exact words. It will be up to you to decide exactly what those words are. Some of the ones that will be fairly clear will be, "I am a threat for a reason." Okay. When Officer Javins finishes up her paperwork, she needs to retrieve her handcuffs. When an officer arrests a person, those are that officer's handcuffs. And when that person is in the custody of the jail, it's normal that they switch out the handcuffs and put jail cuffs on, and the officer takes their cuffs with them should they need to make any other arrest. It is at that point that Mr. Vaughn is going to begin to become agitated, to become upset. He will state that he does not want this officer, a female, touching him. He will say that if they take the cuffs off, he's going to break her jaw. He will make several comments that you will get to hear while Officer Javins is there. And then later on, you will hear from another officer that will talk about comments later on. And all of those comments taken together will be the state's proof for retaliation for past action, which is the making of a threat against an officer for actions taken in the course of that officer's duty.
Mr. Vaughn, you may address the jury if you choose, or you may waive your argument. Mr. Vaughn, do you wish to address the jury?
1 second, Your Honor.
If Mr. Vaughn is going to address the jury, he must do so now.
Your Honor, I wish to waive open statement and reserve for defendant's case in chief.
All right, defendant has waived his right to make an opening statement, so General, you may start your proof.
State calls Corporal Lindsay Javins.
Confirm the testimony you give in this case be the truth, the whole truth, nothing but the truth.
Are you Corporal Lindsay Javins?
Yes, ma'am.
Now, some people say Javins instead of Javins, is that right?
Yes, ma'am.
We are ringing a little bit.
Yeah, I think it's me.
Would you spell your first and your last name for our court reporter?
Lindsey. My last name is Javins.
And how are you employed?
Oh, the City of Dixon Police Department.
And were you working for the city in June of 2022?
Yes, ma'am.
How long have you been in law enforcement?
Since 2017.
And is Dixon Police Department the only law enforcement agency that you've worked for?
No, ma'am. I previously worked for Fairview Police Department.
And on June the 18th of 2022, did you come into contact with the defendant?
Yes, ma'am.
And as part of that conduct, did you end up placing him under arrest?
Yes, ma'am.
We are going to focus on the events once he is taken to jail. So are you and he the only ones in your patrol car?
Yes, ma'am.
Were there other officers on scene earlier?
Yes, ma'am.
So once you arrive at the jail, explain to the jury sort of the Sally Port and how it goes to take someone into the jail.
Yes, ma'am. So whenever you pull into the jail, you drive around the side. There's a front gate. You press a button, tell them what you're there for. They let you in the front gate. And then you go to another gate, and that gate opens. And then you go into a Sally Port, which is essentially like a kind of like a pull-through garage. And it's a secure area to bring whoever into the jail. So we were in that Sally Port area. That's essentially like a garage. There's a door right beside where you would park your car to enter into the jail booking area.
On the ride to the jail, was the defendant, describe his demeanor.
On the way to the jail, like when we first started driving to the jail, we had been joking around and talking. We had just had a pretty reasonable conversation at the police department. We were on good terms at that point in time.
Is that unusual when you're transporting someone?
Not usually. I mean, after a point in time, sometimes people will, start having conversation with you. Sometimes people are mad the whole time. It fluctuates.
And did he remain calm or did he become agitated at some point?
He remained calm until we got to the Sally Port.
What is the first thing that you would pinpoint as him getting agitated?
Whenever he said that my name's not Lindsay, when he was getting out of the car, and then he said that I lied to him like all women do.
And how did it go from there?
So he is stepping out of the car. As he's getting out of the car, he said, "Your name's not Lindsay." And I said, "Yeah, it is Lindsay. My last name is Javins," because our name is on our uniform, and he saw the Javins. I said, "I just typically do first name basis with people because it's easier to remember than Javins. Javins is kind of hard to remember." So he started getting upset about that, and he was like, he said that we had made peace, and then I had lied to him, something to that effect of that I lied to him about my name and that we weren't cool anymore, basically. And then as we start to enter into the jail, that is whenever he said, I'm a threat for a reason. I misheard him, so I said, "What? You're a what for a reason? Or you know what for a reason?" And he said, I'm a threat for a reason.
Is that the only thing he said that gave you concern?
No, ma'am.
Now, I'm going to pass up in just a minute a disc and ask you if you recognize it and give the jury an opportunity to view the video. But could you hit some of the high points of why the statements he made that were concerning to you?
So the first one that was bad was whenever the jail staff was trying to take the cuffs off of him. He was upset because I was assisting the jail staff there was one person on his left arm and there was nobody on his right arm. And there was, who, I don't even know the jailer's name. I presume him to be newer, kind of inexperienced, and he was standing just directly beside us. He wasn't doing much other than he was about to unlock the cuffs. So whenever Mr. Vaughn started pulling around, I went and grabbed his right arm, so just one officer wasn't assisting. At that point in time, he's upset because I'm touching him, and more deputies come, and whenever other people get there, I step back, thinking that if I'm no longer touching him, it's going to de-escalate the situation. And at that time, he said, when her jaw gets broke, it's your fault. And then he continued, fighting with them. And then a female jailer said, will you stop tensing up? We're trying to take these handcuffs off. And he said, excuse my language, fuck no, I'm going to beat that bitch up. Something of that effect. Then, probably one of the things that made me feel uneasy the most is after they got the cuffs off, they walked him to the jail doors for the holding area where they were putting him in. And he said, he looked at me and he said, laugh if you want to. You live in Dixon, Fairview, you talk too much. Implying that I had told him too much information about myself, because I had told him that I'd previously worked for Fairview Police Department. So he was saying to me that I live in Dixon or Fairview, that I talk too much. So I told him too much information about myself.
Did he make any, did he call you by name during any of these threats?
During the actual threats, no. At one point, he did call me by name during the incident inside the jail, yes.
Was anything in his body language suggestive of who he was talking to?
Absolutely. There in several times he was speaking.
Objection, Your Honor. Speculation.
All right, restate your question.
I asked if there was anything in his body language that indicated to whom he was addressing with his threats.
Overrule the objection. She can testify about what she observed and what, that led her to believe, but that goes to the jury to determine whether or not that's reasonable interpretation for what she saw.
Officer, was there anything in his body language that indicated to who he was speaking about?
Yes, ma'am. So whenever he was speaking and he would say her, he was leaning towards my direction. One time he even looked at me. And there's another time that he's walking towards my direction and staring me down right before another officer grabbed him.
I'm going to pass up a disc. We will refer to this as Exhibit 1. Do you recognize what I've just handed you?
Yes, ma'am.
What is it?
It is the disc that contains my body camera footage from that night.
And have you had an opportunity to review it?
Yes, ma'am.
Is it a true and accurate reflection of the events as they happened that night?
Yes, ma'am.
Judge, I would move this in as Exhibit 1.
We'll mark it as Exhibit 1.
And then after the clerk has marked it, I would like to retrieve it. Corporal Javins, did you, and you said that you reviewed it, you actually listened through this a couple of times, is that correct?
Yes, ma'am.
And did you take the time to prepare a transcript of what you heard on that recording?
Yes, ma'am.
Judge, at this point, when I play the body cam, actually, I'll pass up to Corporal, is this the transcript that you prepared?
Yes, ma'am, it is.
And to the best of your knowledge, is it a true and accurate reflection of what is on this recording?
Yes, ma'am. There are pieces that I think that is documented on there that it may say like we couldn't understand what he was saying. There's some things that, especially at the end, that you couldn't hear exactly what he was saying whenever he was in the holding cell. There were only a couple comments that you could actually make out. So it doesn't have every single line, but it is pretty accurate to what's on here is what I heard on the video.
Judge, I have previously provided a copy of this to the defense. I would like to move it in as Exhibit 2 and allow the jurors to have a copy as they listen to the recording.
All right. Ladies and gentlemen, this is a transcript. This witness is prepared based on her interpretation of what you're hearing, about to see and hear on this recording. It is up to you to compare that to what you hear on that to determine whether or not that is an accurate transcription.
Sorry, Judge, the state of Tennessee's firewall was not playing nice with the video.
Ladies and gentlemen, since it looks like we're in a stalled here for a moment, why don't you step across, leave those copies of the transcript in the courtroom and go ahead and step over to the jury room, and we'll call you when we have everything ready. General Bryson, I'm going to step off. As soon as you can get that in working order, let me know. All right, are we ready for the jury? Let's bring the jury in.
Judge, I'll go ahead and say for the appellate record, there are 2 files on this. Yep. For the appellate record, there are 2 files on this, and I will be playing from the second file. And then I'll put my times on when the jury comes in here. All right, Judge, are you ready for me to begin playing?
The key question becomes, why is the defendant so angry? The answer lies in the sovereign citizen belief system. People who follow this ideology often believe laws do not apply to them. When reality hits, handcuffs, arrest, jail, their ego collapses and anger takes over. That anger is clearly visible in the body camera footage. Shouting, aggressive language, and personal threats directed at the female officer. Meanwhile, the judge's reaction remains calm and measured.
You want to get out this way or on that end? Whichever one's easiest for you.
Your name ain't Lindsay.
That's my first name. My last name's Javins. Javins.
So you just lying to me like all women.
My name is Lindsay.
I just gave you respect. I'm taking
Lindsay Javins. Look, I try to be like first name basis with people. Lindsay's way easier to remember than
What you
Javins.
supposed to do?
Yeah, like Lindsay's.
Same way y'all got the last time on the lawsuit. You're straight.
What do you mean?
I'm gonna beat you first. I'm gonna let you know.
There's no
Don't play
reason
with
for
nobody
that.
that's peaceful. Better get you.
I'm not blaming nobody that's peaceful. I was being peaceful until you wouldn't get out of the car.
Disrespectful as I was.
Come on, man.
I'm a threat, though.
Come on,
I'm
man.
a threat for a reason.
What?
I'm a threat for a reason.
You know what for a reason?
I am a threat.
Oh, you are a threat?
Yes, I am.
Okay. Well, I don't know how you mean that, but okay. What did I lie to you about? I'm not playing with
I
you.
don't trust women for a reason, bro. Hey, for real.
I don't trust people that don't listen to me. I've never given them. Look, how are you going to tell me we made peace and then start being mean
No, I'm
again?
just letting you know. I'm just letting you know who I am. It ain't no threat, not my kid.
You kind of just threatened me, but it's
Okay,
cool.
you want to, I'm sure I'm none of it. Feelings don't feel up your stomach. What they were just. Fuck feelings. That's what involved the whole array, is your feelings.
All right.
That's your record.
You say something really spicy? I don't have a problem over here.
He's ready to submit offline.
What?
He's ready to submit offline.
You still go through, you still put it in a supplement?
Who's the sergeant in charge, man?
It's Gonzalez.
Is it the light skin dude?
Huh?
Is he light skin? I call him light skin, okay.
Feels like you're like creeping up here, like, if you didn't know what you were walking into.
Never know what I'm gonna put my head in the
You looked a little scared.
Never scared. I'm not, for sure. I'm playing again.
Nobody else. I see it. Fucking radio.
I got one for every ball in it. Very good.
If he's been arrested,
Mr.
we
Vaughn?
have not received him as a disclosure yet.
You can take those off.
Don't do it.
I would just try calling back in about 30 minutes to an hour. We won't know really anything
Mr.
about
Vaughn,
it.
I gotta leave.
Lindsay, that's your real name, you know
So, I
why?
mean, they would have more information. If you do know what it is.
Take the cuffs off.
She's not in charge of this, kids. I know that's it.
I need my.
Sergeant! Stick 'em off.
Get this fucking shot.
She's not none of that. Don't touch me, I know the sergeant.
I'm leaving, guys.
Yeah, you can call them, and then tell them we're just riding, and they might have some information to give you, but otherwise, I would just call back in about a half hour.
Get her far away from the
All right, listen. I'm just talking about, listen. We won't be cordial. We'll be frank.
Well, because that's my stuff. I need my
I
stuff.
don't trust her.
That's her cuffs.
Bro, I will put myself in your custody and we can go to this cell together. She needs to be away from me. I'm asking you not to take these cuffs off.
Mr.
Until I
Vaughn,
get away from her. Me and you can walk over there. Leave, you tell her to leave me alone. I will not
however you
cause
like
you
it.
any trouble.
I
Fuck
just
the
need this
rest.
shit so I can go.
Fuck the rest.
I need
Play with me if you want to and find out.
I'm sorry.
Go ahead and get the keys. No, you're not gonna move. I'm gonna remove these cuffs off you. Stop pulling back now.
Pull it back. Why is she touching me? A female shouldn't be
Stop
touching me.
moving now!
A female shouldn't be touching me, bro. Look, I'm scared. I'm in fear for my life. She should not be touching me.
Hey,
Alright?
nobody wants to hurt you.
Why is she touching me? I don't trust her. Get her off of me.
I hear you.
Please get her off of me.
Nobody wants to hurt you, just go with the flow.
So with the flow, get her off of me. I don't need her touching me. Y'all can handle me. I said I wasn't gonna.
Nobody's touching you anymore.
Stop pulling back now!
Fucking touch me.
She's not touching you!
She fucking touch me.
She's not touching you right now.
She's not touching you anymore.
Stop. Relax.
She's not touching you.
Relax.
Her hands are off you right now.
I just told you I would. I ain't gonna give you no problem. She ain't got no goddamn reason to touch me. When I don't get broke, it's your fault. Give a fuck about the law.
Sorry. Hey, we're trying to get the cuffs off you. Can you stop tensing up, please?
Fuck no, cause I'm gonna beat that bitch up. Down there. Y'all think everybody playing. You laughing. You live in Dixon, Fairview, you talk somewhere. We get some problems. When you shake me up here.
I'm sorry. He just wants to act bad since he's in here. He's perfectly fine the rest of the time. Just trying to act hard. Here's his copies right here. That's all he had, was just whatever was on.
I've had it now,
Just shoes.
That's all he had. Didn't have anything else. Original call for domestic. He was threatening to kill his kid.
Judge, we have
This is not weakness. It is authority. A judge's role is not to match emotion with emotion, but to enforce the law with discipline and neutrality. Judge David D. Wolf maintains control throughout the proceedings because courts run on procedure, not outrage. He uses clear instructions, plain language, and repeatedly reminds a jury that an indictment is not evidence and that the burden of proof always rests with the state. This ensures the defendant's theatrics do not emotionally influence the jury. The officer's testimony establishes that the threats were specific, targeted, and made in direct response to her official
stopped play at 22 hours, 37 minutes, and 59 seconds.
All right.
Judge, I am going to keep this queued up in case during his cross-examination, the defendant wants to play any portion of this.
All right, then we'll turn the lights on.
Did this interaction at the jail happen in Dixon County?
Yes, ma'am.
Did you have you had any interaction with the defendant outside of your capacity as a law enforcement officer?
No, ma'am.
These comments taken as a whole, did you mention this to another officer?
Yes, ma'am.
And that officer encouraged you to document these.
Yes, ma'am.
Why did he encourage you to document these?
He encouraged me to document the information.
Objection, Your Honor, speculation.
Overruled.
Why did he encourage you to document these?
He encouraged me to document it in my report just in case any further action happened, as if he did try to retaliate against me, did try to assault me or anything like that. Say if I, saw him out in public somewhere.
Let's talk about assault. You did not seek charges for him on assault that night.
That's correct.
And that's because he didn't hit you that night.
Yes, ma'am.
And that is a different legal charge than the retaliation.
Yes, ma'am.
Objection, Your Honor, leading.
Sustained. Don't lead the witness.
The charges of assault and retaliation, do those have separate elements?
Yes, ma'am.
Nothing further.
Mr. Vaughn, do you have the right to cross-examine the witness? Do you wish to ask any questions?
Yes, sir, I do. Just take it off. Good afternoon. Is it Corporal Jarvins?
Javens.
Javins, sorry about that. Is this is a testimony you wrote, correct?
That is, yes, sir.
Here,
That
she'll
is-
read
I
it.
wouldn't say it's a testimony, but it's what I wrote, yes.
Okay. This was because the video was, it was difficult for you to hear, correct? The reason you wrote this?
I wrote it out for myself, and then I shared it with Miss Bryson, or General Bryson, sorry.
So you needed to recall it better for the jury, correct? Yes.
No, sir, I remembered what happened.
Okay. You, how long ago was this?
In 2022.
Okay, you remember what happened. Are you sure you didn't just write this out because you forgot what happened and you just wanted to, so I'm sorry, excuse me. I'm brain farting here, I'm sorry.
Okay.
So, you wrote this out so that you wouldn't forget what happened for the jury, right, correct?
I wrote it out while I was reviewing my video. I think that it's important that I did that because there were a lot of direct statements that were made that I think the accuracy is important.
Okay, so you remember it from the video or you have firsthand knowledge?
Yes, sir, from the video.
Oh, okay. So you only remember the threat and for retaliation from the video? Or, I mean, because let me ask you this instead. So you arrested me for retaliation. No, you didn't. I was charged with retaliation, correct? Retaliation and past act.
Yes, sir, that was presented to a grand jury and it came back with a true bill.
So that wasn't the original charge, was it? That the reason I was arrested and taken to the jail, was it?
No, you were taken to jail for a different reason.
Okay. And you didn't charge me that night with retaliation or past act, correct?
No, sir.
Okay. Did I tell you that I was scared of women at any time during the traffic stop?
Yes, sir.
I did. Did you believe that to be true?
Not entirely, no, sir.
Oh, so you took it as joking or lying per se?
I didn't believe that you were scared of all women, no, sir.
Okay. there another female judge present who had her hands on me at the time when these statements were made? When they were trying to remove the cuffs?
Yes, sir. Yes, sir.
And you didn't never hear me say your name at all or direct that towards you, that I want to do anything to you?
You looked at me and you said, Lindsay, if that's what your name is, because you were upset because you thought I lied to you. And then during that time, that between the two threats of breaking my jaw and beating me up, you called me a lying ass hoe or lying ass bitch, one of the two.
Okay. Your Honor, can I ask my question, please?
You may consult. Ladies and gentlemen, for further explanation, Mr. Spratt was appointed by this court as advisory counsel. He is not participating on an active basis, but he's there to give advice because of the fact that Mr. Vaughn had requested to be able to represent himself. So.
Okay, in the video we just watched, I'm sorry, your name is Miss Jarvin. Sorry, Jarvin, you got to keep forgiving me for that. I'm horrible with names.
You're fine. And last name is Javens.
Javens, okay. The video we just watched, you said he's trying to act bad because he was in there before and he was perfectly fine the whole time. You said that, right?
At the end, I made a comment that you were acting different than you were before we got to the jail, absolutely.
You were laughing too also, right?
Yes, sir.
Okay. So felt no threat at the time at all that night, did you?
Threats were made to me, yes.
So you didn't feel threatened,
I did feel threatened.
but you're laughing feeling threatened?
I think that a part of my job, we are frequently faced with fear that we don't show. I've been faced with life and death situations and I didn't show fear.
So you had no threats or interactions with me since then?
The only interaction I've had with you since then is in court.
I think this would be safe to say that I feel like these charges were a retaliation from you instead of from me due to the fact that you arrested me for illegally. Would you agree?
Mr. Vaughn, you are making a statement rather than asking a question. It has to be in the form of a question. You'll be allowed to testify if you choose to do so, but this must be in the form of a question for this witness.
Okay. Would you say that the original arrest was illegal?
No, sir.
Let me see here. I got some more questions for you. What was your original charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please. Ladies and gentlemen, step across the way, please. Okay, we're walking a fine line. You've asked her a question about the original arrests. The original arrests were for driving on a revoked license, third offense, and for the second count, which the court, I think, the state resisting arrest, which I think the state had acknowledged. My concern is that opening the door to the evidence coming in about you're having two prior, being driving on a revoked license, third offense, and that's why I wanted to caution Corporal. I just want you, if you can answer his question about driving on a revoked license, just don't add the third offense part.
Okay.
Is that
Yes,
all
sir.
right?
Yes, sir.
All right. Then that's the only thing. Any objection to any of that? Step back and talk to your advisory counsel. Let me step off the bench for a second. Mr. Spratt, I'm going to give you some leeway and from these, but I'm not going to keep delaying this trial for you two to confer, so make it quick. Understand, and that's why I'm simply advising you both. I'll give you an opportunity to consult. That's what elbow counsel or advisory counsel does. But there is a point where it's delaying the trial, and we're not going to continue to allow that to keep happening if it's going to be. That's fine. As I say, I'm not complaining. I'm just saying it's already almost 2:30 in the afternoon. So, what happened to our district attorney? All right, gentlemen, we're ready for the jury.
Yes, Judge.
Bring the jury in.
Excuse me, Your Honor, 1 second. I'm aware of the charges that I'm being charged with, and I don't want to hinder.
That is why the prosecution pushes a retaliation charge, even without physical assault. In simple terms, this case is a power struggle. On one side, law, process, and patience. On the other, entitlement, frustration, and rage. The judge stays calm because the system is built on rules, not anger. And the defendant is angry because his imagined freedom cannot survive inside a real courtroom.